שלום לכולם, אחר הצהריים טובים. אני דקלה גרשוני, מאגף מדיניות והסכמי סחר במינהל סחר חוץ, משרד הכלכלה והתעשייה. המשבר המצער על אדמת אירופה והמתחים הגיאופוליטיים הגואים בעולם הינם בעלי השלכות כלכליות גלובליות. מאז תחילת הלחימה בין רוסיה לאוקראינה הופעלו סנקציות כלכליות נרחבות על רוסיה, שעל החברות הישראליות להקדיש תשומת לב מיוחדת אליהן. כמו גם למגבלות שארצות הברית פרסמה ביחס ליצוא לסין. במטרה להנגיש לחברות הישראליות מידע עדכני בנושא, ארגנו את הוובינר היום בשיתוף מינהל הפיקוח היצוא הדו-שימושי ומשרד החוץ. אני רוצה להודות מאוד למשרדי עורכי הדין שנרתמו למשימה והכינו עבורנו מצגות לשיקוף המציאות העדכנית ביותר. משרד עורכי דין בליס בבריסל, ארנולד ופורטר בארצות הברית, ותודה מיוחדת למשרד עורכי דין שיבולת בישראל. אבקש להודות גם לנספחים שסייעו, לנספחת הכלכלית שלנו בוושינגטון, נטלי גוטמן חן, ולעמי לוין, הנספח הכלכלי לאיחוד האירופי, הממוקם בבריסל. מספר הערות טכניות לפני שנתחיל. הוובינר מוקלט ונעלה את ההקלטה יחד עם המצגות של הדוברים לאתר מינהל סחר חוץ. כמו כן, הסשן הראשון שנקיים של דברי פתיחה יהיה בעברית, ולאחר מכן נעבור לאנגלית. תחילה הזכרו את המצב של הסנקציות באיחוד האירופי ובריטניה, משרד עורכי הדין בליס, ולאחריו בארצות הברית ארנולד ופורטר. ארנולד ופורטר גם ירחיבו על המגבלות על סין. בחלק האחרון משרד עורכי דין שיבולת יערוך פאנל יחד עם המומחים הזרים על case studies אשר יעזרו לכן החברות לקבל כלים מעשיים. Without further ado, אני שמחה להזמין את אוהד כהן, מנהל מינהל סחר חוץ במשרד הכלכלה והתעשייה, לומר מספר מילים. אוהד, בבקשה.
תודה רבה דקלה, אני מקווה ששומעים אותי בסדר. אז שלום רב לכולם וברוכים הבאים לוובינר בנושא הסנקציות הבינלאומיות על רוסיה והמגבלות על סין. כפי שדקלה אמרה, המשבר שפוקד את אירופה על רקע אירועי השנה האחרונה לא פוסח גם על כלכלת ישראל ועל יחסי הסחר של ישראל עם העולם. חברות ישראליות שפועלות בשווקים הבינלאומיים צריכות להיות מודעות לסנקציות הקיימות על רוסיה ובלרוס. חלק מהסנקציות האלה שהוטלו על ידי מדינות שונות, וביניהן ארצות הברית, האיחוד האירופי ובריטניה, עשויות להיות מאוד רלוונטיות ולהשפיע על אותן חברות ישראליות, ועל כן אנחנו מקיימים את הוובינר על מנת להרחיב בנושא. משטר הסנקציות הוא דינמי, ומשכך המידע שמובא בוובינר הזה עשוי להשתנות בהתאם, ובאופן דומה גם המידע על המגבלות שהוטלו על סין. אני מאוד ממליץ לעקוב אחרי המידע המתפרסם בנושא באתרים הרלוונטיים שיצוינו במהלך הוובינר ובתקשורת העולמית. בנוסף, מינהל סחר חוץ ומשרד הכלכלה והתעשייה השיק לאחרונה אתר חדש, ובו קיים מידע רחב בנושא זה, כמו גם קישורים למקורות מידע נוספים, ואנחנו ממליצים לכם לבקר בו ולהתעדכן בזמן אמת. אני לא עורך דין, אבל בכל זאת דיסקליימר, חשוב לנו להדגיש כי משרד הכלכלה והתעשייה מציע את המידע כשירות לציבור למטרות כלליות ואינפורמטיביות בלבד. הוובינר לא בא להחליף ייעוץ מקצועי, והאחריות היא בסוף של החברות לפעול על פי שיקול דעתם ובכפוף לכל דין. מכיוון שהמידע שיועבר בוובינר הוא מורכב ומסועף, אנחנו ממליצים לחברות שבוחנות את השפעת הסנקציות עליהן, גם להתייעץ עם משרדי עורכי דין בכל הקשור לייעוץ המשפטי. מינהל סחר חוץ ממשיך לפעול על מנת לסייע לתעשייה הישראלית להתמודד עם אתגרים בזירת הסחר הבינלאומית בנושא הסנקציות, ואנחנו מזמינים אתכם לפנות אלינו בכל עת באמצעות כתובת הדואר שניתן למצוא באתר המינהל, ושתישלח בהמשך למשתתפי הוובינר. לבסוף, אני מבקש להודות לשותפים הטובים שלנו בוובינר, לאופיר גור, עמיתי, מנהל מינהל פיקוח ייצוא דו-שימושי, לקרן שחר, סגנית בכירה ליועץ המשפטי במשרד החוץ, ומי שעומדת בראש כוח המשימה הבין סוכנותי בנושא סנקציות, כמו כן לנציגים מהסקטור הפרטי, לנעמה מרגלית מפירמת עורכי דין שיבולת, לאיזבל ונדם ואנטיגוני מטאו ממשרד עורכי דין ובליס בבריסל, ולג'ון ברקר ממשרד עורכי דין ארנולד פורטר בוושינגטון די.סי. אני מאחל לכולנו וובינר מעשיר ומלמד, ותודה רבה.
תודה רבה אוהד. כעת אני מזמינה את אופיר גור, מנהל מינהל הפיקוח על הייצוא הדו-שימושי במשרד הכלכלה והתעשייה.
אז תודה רבה דקלה, והמון תודה אוהד על הדברים. אחר צהריים טובים לכולם. עברו כ10 חודשים מאז הוובינר האחרון שערכנו בנושא, ולאור שאלות שהגיעו אלינו על ידי חברות רבות לאורך התקופה, החלטנו, משרד הכלכלה יחד עם כוח המשימה, לערוך את הוובינר היום, שאני מקווה שיסייע להבנה והיכרות של הסנקציות והמגבלות הנוכחיות של ארצות הברית, האיחוד האירופי ובריטניה בהקשר הרוסי והסיני. קודם כל, כשאנחנו מדברים על סנקציות, מגבלות אחרות או כללי פיקוח על הייצוא, חשוב לזכור שיש אפשרות למדינות להחליט שהן מכילות את הפיקוח שלהן מחוץ לגבולותיהן, כלומר, יש לחקיקה שלהן תחולה אקס-טריטוריאלית. הדוגמה הראשית והבולטת ביותר למדינה שיש לה פיקוח אקס-טריטוריאלי משמעותי היא ארצות הברית, הגם שגם לאיחוד האירופי יש פיקוח כזה, כפי שנשמע בהמשך. כלומר, חברות ישראליות עשויות להיות כפופות לפיקוח אמריקאי או אירופאי, גם אם כל הפעילות שלהן מתבצעת בישראל. לאור עיקרון זה חשוב לי להדגיש 2 נושאים מרכזיים שלדעתי יסייעו לחברות ישראליות להיערך לקראת סביבה בינלאומית משתנה. המונח הראשון שאני מאמין שחשוב להכיר, להבין ולזכור הוא Internal Compliance Program. ניתן לתרגם זאת לתוכנית ציות פנימית של החברה, ומדובר בעצם בהליכי בקרה פנימיים. תוכנית הציות הפנימית צריכה להיבנות באופן ייחודי לכל חברה, כך שתוכל לענות על הצרכים והדרישות החוקיות שחלות עליה. מונח נוסף שחשוב להכיר הוא Know Your Client, KYC, או בעברית, הכר את הלקוח שלך. בהקשר זה יש חשיבות רבה לביצוע בדיקת נאותות, due diligence על הלקוחות. קרן שחר, שעומדת בראש כוח המשימה, תפרט בהמשך קצת יותר על הנושא הזה, שגם יורחב על ידי הפאנליסטים בוובינר. בגדול חשוב מאוד שחברות העוסקות בייצוא מפוקח, יאמצו תהליכי בדיקה של הלקוחות שלהם לפני ביצוע העסקאות. עיקרון זה בא להבטיח שהיצואן יבחן את העסקה ואת הלקוח שלו כדי לעמוד בחובות הרגולטוריות החלות עליו, ולמנוע עשיית עסקים עם גורמים שנמצאים תחת סנקציות או שהמסחר איתם מוגבל. אני מאמין שהדברים הכי חשובים שכולנו צריכים לקחת מהוובינר היום הם קודם כל, הכרה ראשונית של מספר הסנקציות והמגבלות השונות וכיצד הוא יכול להשפיע עליכם, ולאחר מכן, בחינה מעמיקה של שרשרת האספקה שלכם, אימוץ תוכנית ציות פנימית שתכלול בדיקות מעמיקות של הלקוחות שלכם, והליכי בקרה נאותים על פעילות של ייצוא מפוקח. אני מאחל לכולנו אירוע מוצלח. תודה.
תודה רבה אופיר. אני מבקשת להזמין כעת את קרן שחר, סגנית בכירה ליועץ המשפטי במשרד החוץ, ומי שעומדת בראש כוח המשימה הבין-סוכנותי בנושא סנקציות, לומר דברי פתיחה. קרן, בבקשה.
תודה רבה דקלה. תודה למשרד הכלכלה, ובמיוחד לאוהד, אופיר, לנה ודקלה על ארגון הוובינר השני בנושא ממשקים פוטנציאליים של חברות ישראליות למול סנקציות על רוסיה ובלרוס ומגבלות על סין. כוח המשימה הבין-סוכנותי שבראשו אני עומדת, נועד לרכז ולכוון את יישום המדיניות הישראלית בנושא סנקציות, שבהקשר הרוסי, המדיניות הישראלית קובעת שישראל לא תהווה מקום שבו יעקפו בעין וקוף סנקציות אמריקאיות על רוסיה. אחת המטרות של כוח המשימה היא לשקף למשק הישראלי את המשמעות של הסנקציות הבינלאומיות, גם כאשר ההחלטה הסופית ולכן גם הסיכון יהיה על האדם, החברה או הבנק הפרטיים עצמם. לשם כך, כוח המשימה ממפה ומנתח את הסנקציות הבינלאומיות, בעיקר את אלו שמוטלות על ידי ארצות הברית, ופועל מול המגזר הציבורי והפרטי בישראל על מנת למנוע עקיפה אפשרית של הסנקציות בישראל. הכוח מבצע בחינה מתמדת ויסודית של כל המגזרים הרלוונטיים, על מנת לאתר ולמנוע אירועי עקיפה. ברגע שמתגלה פער, הוא פועל ובעצם עובד יחד עם הרשויות המוסמכות הרלוונטיות כדי לטפל בפער. כוח המשימה הבין-סוכנותי מונה כ-90 נציגים מכלל משרדי הממשלה, הרשויות והגופים בישראל. הוא עובד עם רגולטורים במשק, החל מהמערכת הפיננסית, שוק ההון, משרד האוצר, דרך משרד הכלכלה, רשות החדשנות, כלל גורמי הסחר, ועד למשרדי החקלאות, האנרגיה, המדע, התחבורה, הביטחון ועוד רבים אחרים, ובשיתוף גם המל"ל. המדיניות הישראלית למניעת עקיפת סנקציות, כמו גם ההשלכות הפוטנציאליות של הסנקציות הבינלאומיות, האמריקאיות, האירופאיות, הבריטיות, על גורמים ישראלים, מחייבות חברות ישראליות לנהוג באחריות ולבצע ניהול סיכונים של פעילות עם זיקה לסנקציות. זה כולל כמובן את מה שאופיר גור ציין לגבי KYC, Know Your Customer, ובדיקת נאותות לגבי הלקוח, אבל לא רק. יש הקשרים נוספים משמעותיים לא פחות, שחשוב לבחון כאשר מבצעים ניהול סיכונים. הקשרים אלה כוללים את המוסד הפיננסי המעורב בעסקה מהצד השני, זיקה פוטנציאלית לישות מוכרזת, כולל בעלות על ידי ישות מוכרזת, כולל שרשרת האספקה, חברת השינוע, כלי השיט או הטייס שבאמצעותו מגיעים הטובין או יוצאים, הגורמים המבטחים, הגורמים המממנים, לפעמים גם הסקטור שקשור לעסקה, ולפעמים גם האזור הגיאוגרפי אליו נועד הייצוא או ממנו מגיע היבוא. בקשר לסקטור שקשור לעסקה, חשוב לציין שקיימים סקטורים שהם מוחרגים מסנקציות, כמו למשל חקלאות ומזון, ומצד שני קיימים סקטורים שנתונים לכשעצמם בסנקציות, כמו למשל היהלומים. במהלך השנה האחרונה קיבלנו פניות לא מעטות לגבי מקרים שקשורים לבנקים הישראלים. חשוב לי לציין בהזדמנות הזו שהבנקים הישראלים מיישמים את הסנקציות הבינלאומיות כחלק מניהול הסיכונים להם חשופים תאגידים בנקאיים. הם מחויבים לנקוט בזהירות נאותה בעת ניהול המוסד הפיננסי. המפקח על הבנקים אומנם הוציא בתאום עם כוח המשימה הבין סוכנותי, מכתב שמבהיר שלצד חובת מתן השירות, ביצוע פעולה או הימנעות מביצועה, משיקולי סנקציות הוא לגיטימי, במסגרת ניהול הסיכונים הבנקאי. אבל בשורה התחתונה, ההחלטה הנקודתית לגבי כל מקרה ומקרה, נתונה לשיקול דעת הבנק עצמו. כוח המשימה אינו יכול להתערב בשיקול דעתו של תאגיד בנקאי לעניין ניהול הסיכונים. במקרה שלמישהו יש בעיה, ואלה עיקר הפניות שקיבלנו, ברגע שלמישהו יש בעיה במשהו שקשור לבנק, בהקשר של סנקציות, מומלץ לפנות בראש ובראשונה לבנק עצמו, כדי להבין את הסיבה לחסימה או לסירוב. במקרים קיצוניים אפשר לפנות גם למפקח על הבנקים, אבל אני מדגישה שוב, אין לנו אפשרות להתערב בניהול הסיכונים של הבנק למול הסנקציות בינלאומיות. עניין חשוב נוסף שעולה בהקשר של הבנקים, הוא שאישור הבנק לעסקה לא משמש קלירנס לכללי, לזה שעסקה היא לא מהווה עקיפת סנקציות. כלומר, במהלך השנה נתקלנו בטענות של חברות, לפיהן אם הבנק אישר את מימון העסקה, אז חזקה על העסקה שהיא נקייה מסנקציות ואיננה בעייתית. אני מבקשת להבהיר שאישור של מוסד בנקאי איננו מהווה תחליף לניהול סיכונים והליכי בקרה פנימיים של כל חברה וחברה. הבנקים לא מודעים, וגם זה לא תפקידם להיות מודעים, למשל באיזה כלי שיט משנה היבואן את הטובין שרכש. גם אם היבואן קיבל מימון מהבנק לעסקה מסוימת, אם למשל כלי השיט שבאמצעותו יגיע הטובין לארץ יהיה נתון לסנקציות, עלולה להיות בעיה אמיתית בכניסתו של אותו כלי שיט לנמל ישראלי. לסיכום, הוובינר הזה נועד כשירות של משרד הכלכלה בשיתוף כוח המשימה להעמקת ההיכרות עם הסנקציות הבינלאומיות על רוסיה והמגבלות הבינלאומיות שהוטלו לאחרונה על סין, ולסייע להבנת הממשקים וההשפעה הפוטנציאלית על גורמים במשק הישראלי. כל גורם רלוונטי צריך לבחון את עצמו, לאמץ תוכנית ציות פנימית לסנקציות ולמגבלות שיפורטו בהמשך על ידי משרדי עורכי הדין, לנהל סיכונים, וככל שיש צורך להתייעץ עם עורכי דין, בדיוק כפי שאוהד המליץ גם קודם. עם עורכי דין כמובן שהם מתמחים בתחום הסנקציות הרלוונטיות. למשל, סנקציות אמריקאיות, להתייעץ עם עורכי דין שמתמחים בסנקציות אמריקאיות ובקומפליינס כמובן. ככל שיש שאלה עקרונית, ניתן לפנות לגוף הממשלתי עמו החברה מצויה בקשר. בדרך כלל זה יהיה הרגולטור הרלוונטי לחברה, לתחום העיסוק של הפונה, של החברה שפונה, ובאמצעותו אפשר להגיע לכוח המשימה. כמו שאמרתי קודם, אנחנו נמצאים בכל משרדי הממשלה ועובדים בשיתוף עם הרגולטורים, כך שבסופו של דבר כל פנייה כזאת תגיע אלינו. אני מודה לכולם על ההיענות הרחבה להשתתפות בוובינר, ומקווה שהוא יהיה לעזר. תודה.
תודה רבה קרן על דברי הפתיחה המעניינים, וכעת נעבור לאנגלית. Thanks again to our distinguished guests from Washington, D.C., Brussels, and Israel. We will start with a presentation of the EU and UK sanctions. I would like to present Van Bellen Bellis law firm. Van Bellen Bellis is a Brussels-based law firm specialized in the EU law and international trade law. The firm also has offices in London and Geneva. Van Bellen Bellis has a large expert team helping clients with sanctions and export control compliance questions. And today we have with us two experts. Isabel Van Dam is a partner at Van Bellen Bellis and a visiting professor at the College of Europe. She specializes in EU law and international trade law. She assists clients with matters involving compliance with export control legislation and UN, EU, and national sanctions. She previously was a referendar in the Chambers of Advocate General Sharpstone at the Court of Justice of the European Union, where she worked on several high-profile sanctions cases. Antigone Matteo is an associate at Van Bellen Bellis. She specializes in EU law and international trade, focusing on international dispute settlement. She assists clients with matters relating to the scope and application of EU national export control legislation and sanctions. Isabella Antigone, the floor is yours.
Thank you very much for that kind introduction. We will introduce you to the updates regarding the EU sanctions and the UK sanctions relating to Russia and Belarus. And I hope that my colleague Antigone could now share the presentation. In general, we want to remind you of the fact that when we speak about European sanctions, we speak about sanctions that are adopted by the European Union, by the EU institutions. These sanctions are proposed by the Commission, the European Commission, and then adopted by the Council. There are the Russia sanctions and Belarus sanctions, but of course the European Union has adopted many other sanctions regimes. And in the presentation that you will receive after this webinar, there'll be a link to the EU sanctions map that outlines all of the various sanctions that apply. At UK level, the UK now adopts its own sanctions after Brexit, and those are adopted by the Secretary of State of the FCO office. These sanctions, to a large extent, overlap with the EU sanctions, but they're not identical. So it's not sufficient to verify that you comply with the EU sanctions to conclude that you also comply with the UK sanctions. These analyses have to be done separately. Now, with that general background in mind, let's look at the circumstances in which an Israeli company or an Israeli national might need to comply with the EU and UK sanctions. It is generally understood that the EU sanctions, and the same applies to the UK sanctions, do not have an extraterritorial scope. And I think that this question will be mentioned in several of the presentations today. But the fact that the EU sanctions do not have extraterritorial reach does not mean that an Israeli company or an Israeli national cannot easily fall within the scope of the EU sanctions legislation and need to comply with those sanctions. First of all, the EU sanctions apply within the EU territory. So if you are an Israeli national acting from the UK territory, or you have employees who are remotely working from an EU member state, they are present on the EU territory and they have to comply with the sanctions. Second, it applies to nationals of EU member states. This means that if you are a dual national of Israel and EU member state, or your employees are, they have to comply with EU sanctions legislations wherever they are. So also dual nationals who are working from Israel need to comply with the EU sanctions legislation. Third, the EU sanctions apply to entities incorporated or constituted under EU member state legislation. What this means is if you are an Israeli company, but you have EU subsidiaries, then the EU subsidiaries need to comply with the EU sanctions legislation. Fourth, the EU sanctions apply to any business that is done in whole or in part within the EU. This means that if you are an Israeli company and you are doing business in the EU, for example, because you are involving an EU bank or an EU insurer or an EU reseller in your transaction, or you are part of a broader group incorporated in Luxembourg that needs to approve your transactions, that you are doing business within the EU. This is a very broad jurisdictional basis, and many of the activities that you might be undertaking might be covered by EU sanctions legislation because of this very provision. And then finally, it applies also aboard any aircraft or vessel under EU member state jurisdiction. In sum, for EU-Israeli dual nationals and for Israeli companies that have clear links with the EU territory or their transactions have clear links with that territory, there is probably the need to comply with the EU sanctions. Now, in respect of the United Kingdom, the analysis is quite similar in terms of compliance with the sanctions, although the test looks a bit different and looks a bit more simple, in fact. The UK sanctions apply to the conduct of any person in the UK or its territorial seas. There's also a company acting within the UK, or then a UK person wholly or partly outside the UK. So here again, it's the same message. There is no strict extraterritorial scope of application of the sanctions, but it might be quite easy to fall within the scope of those sanctions as an Israeli company or as an Israeli UK national. And I would add that while the European Union has given some guidance on when the sanctions apply to a third country company, such as an Israeli company, the United Kingdom, unfortunately, has been less forthcoming with giving that guidance. So there's less certainty in that respect. So extra caution and care is needed in respect of the UK sanctions. So assuming that the EU and UK sanctions apply, let's have a closer look at what that actually means and what are the sanctions with which you need to comply. I will focus on the targeted and financial sanctions, and then my colleague will speak, Antigone will speak more about the trade sanctions. The targeted sanctions are the sanctions that often attract the most interest. Targeted sanctions are sanctions that apply because a person, a company, or any other entity is included in the EU sanctions list. This is by now for Russia a very long list. This includes, of course, people who somehow have been involved in the war in Ukraine or have been benefiting or supporting those actions of the Russian government. But here there is a significant new development. The European Union has now added a new basis to include a person or a company or an entity in this list, namely anyone who facilitates the circumvention of the EU sanctions. If you need to comply with the sanctions, you cannot circumvent them. So you can't undermine the sanctions. But even if you do not need to comply with the EU sanctions, the EU now makes it clear that, for example, an Israeli company that does not need as such to comply with the sanctions cannot facilitate circumvention, because otherwise there is a risk that that company will be included in the EU sanctions list. This ground has not yet been tested, but it means if you, for example, have a European business partner, and they come to you and they say, we can no longer engage in this transaction with this Russian partner because of the EU sanctions. And they come to you as an Israeli company and ask if you could do the transaction on their behalf somehow, that immediately a red flag needs to arise, because it is most likely that this could involve a type of circumvention of the EU company, of the EU sanctions, and that the Israeli company is becoming involved in a scheme to facilitate the sanctions circumvention. So here we caution that you are very careful in engaging in any such of transaction. Now, assuming that you are dealing with a person, an entity, a company from Russia, or you yourself become listed, what are really the consequences? And the consequences are very grave, because the first point is that in respect of any person or entity or company included in this list, the assets, the funds, the economic resources of these persons and entities need to be frozen. This means that nothing can change in respect of these assets. It also means that the listed person or entity cannot access these assets. To give an example, if you're an Israeli company that needs to comply with the EU sanctions legislation, and you have a Russian shareholder who is included in the EU sanctions list, you need to make sure that nothing happens to those shares, that they are frozen, and that the Russian shareholder in no way can exercise any shareholder rights. The second important consequence in practice is that if a person or entity is listed, then no funds or economic resources can be made available to that person. This is the most important obstacle in practice when engaging in transactions with Russian parties. This means, in essence, that you cannot do anything that economically benefits this listed person or entity. Now, how do you go about to comply with this sanction? If you're involved in a transaction and you see that there's any link with Russia, you should be screening the parties to that transaction. And the first thing to do is to check whether the parties to the transaction are somehow listed. So you go to the EU sanctions list and you can search for these persons or entities. But if you've done that and you conclude that they do not appear in the list, that's not the end of the analysis. In fact, if the person or entity is not listed, you have to check if they nonetheless are owned by a listed person. And here there's a 50% threshold that applies. If they're owned by a listed company, then that means that you cannot do anything with that business partner in Russia. Also, and this is even more complicated to assess, you need to verify whether your business partner is perhaps controlled by a listed person or entity. This is a very complex factual assessment and requires a high due diligence duty to verify whether any listed person or company is exercising decisive influence over your business partner. How to go about that is by these days, there's a lot of various commercial databases that can be used for this purpose, but they are typically not sufficient. You will, in most cases, will need to send a questionnaire to your business partner and ask very detailed questions in order to ascertain whether they're owned or controlled by a Russian listed person or entity. Now, apart from these targeted sanctions, so assuming that you found that there is a problem because there is a link with a listed person or entity, we'd recommend that you cancel the transaction or at least that you suspend the transaction to assess what mitigation measures can be taken. Now, there are situations where you might be able to ask for an authorization of a license. This means that something that you're not allowed to do in principle, you might nonetheless be authorized to do it for specific purposes that we have listed here. This involves that you need to first go to a member state authority and ask for the license. And these conditions are then strictly assessed. In addition, you might want to check if there's a carve out to the sanction. So to the targeted sanctions, there are certain exceptions, things that are still allowed. So that's something else that needs to be verified. And if you fall within the scope of a carve out, then there is no need to go to a member state authority and ask for a license. Now, apart from these targeted sanctions and checking this list of Russian listed persons or companies, we also caution to be careful when dealing with Russian state-owned enterprises, because the EU has also prepared a second list that includes these Russian state-owned enterprises. And basically, you can't engage in any transaction with any of these companies or with companies that are owned or controlled by these entities. So here again, specific care is needed. Now, apart from these targeted sanctions and particular restrictions on Russian state-owned enterprises, as I already mentioned, there's also a broad set of financial sanctions that apply. And we won't go into detail about each of these complex financial sanctions, but it's sufficient to outline that any type of financial engagement with a Russian business partner needs to be carefully examined and scrutinized. Because, for example, there's various limitations on corporate finance. if you're an Israeli company and you're dealing in crypto assets with a Russian business partner, that might be a problem. There's limitations on sovereign debt dealings, on public finance procurement. If you're involved in any type of energy project in Russia, that needs to be carefully examined. And also if you're involved in any investments with a Russian direct investment fund. Also, if you're providing any type of financial or business services, that needs to be closely scrutinized. So that sums up the targeted and financial sanctions. And I'll now turn to my colleague Antigone to talk more about the trade sanctions that apply. Thank you.
Thank you, Isabel. Turning now to the trade sanctions. There are four main blocks of restrictive measures that form what we call the trade sanctions. The first two relate to trading goods, and the first one has to do with export-related restrictions. What is prohibited under the export-related restrictions is any form of sale, supply, transfer, or export of certain specifically listed goods and technology that are identified in annexes in the EU sanctions legislation. Now, how can this become relevant for an Israeli company? As Isabel mentioned before, in cases where an Israeli company is involved in a transaction where it sells certain goods that are listed through an EU reseller or makes payments through an EU bank, then even if the goods are not exported from the European Union, it is possible that the export restrictions might apply. In terms of the goods that are covered by these export-related restrictions, we have a very broad list of goods and technology that ranges from cigars or vodka to advanced electronics and heavy machinery. Now, although the origin of the goods, for example, whether they are EU originating goods or their location before they are traded is not relevant for the application of these export restrictions, their end destination is the key. So the export restrictions apply to the transactions that have as end destination Russia. On the other side of this coin, we have the import-related restrictions. And there, the types of transactions that could be covered and therefore prohibited is the import, purchase, or transport of the listed goods. Again, here we have annexes where various types of goods are listed and identified most of the times by their HSS or common nomenclature code by virtue of their classification. Although these goods are similar to those subject to the export restrictions, they are not identical. And here, when we're talking about purchase restrictions, what matters is not so much the destination of the transaction. For example, if we have a purchase where the goods are shipped into the European Union, but instead whether the goods are originating or have been exported from Russia. For an Israeli company, this could mean that if we have, for example, an Israeli branch of an EU company that is located in Israel, and it is purchasing products from a third country, for example, Armenia or Morocco, and those products are Russia originating, then these restrictions would apply. In terms of the types of goods that are covered under these restrictions, again, we see a very broad list of goods that can cover from caviar to petroleum and oil products. Although these restrictions apply with respect to Russia, very closely resembling restrictions apply with respect to Belarus. Although the types of goods are not identical when it comes to the Russian sanctions and the Belarus sanctions, there is a high degree of convergence, but there are some additional restrictions that apply with respect to Belarus, while other restrictions that apply with respect to Russia do not necessarily apply with respect to Belarus. That means that if you have a transaction that touches both relates both to Russia and Belarus, separate checks need to be done under the two sanctions regimes. Now, the last two blocks of the trade sanctions have to do with services. On the one hand, the EU sanctions prohibit the provision of any services that relate to the goods and technology that are subject to the import and export related restrictions we just mentioned. you see here that there are certain categories in the slides of services that are prohibited. However, the key takeaway as regards the related services is that when an Israeli company is prohibited to provide, to sell certain types of goods, at the same time, they are prohibited to provide any type of service that would support persons in Russia from obtaining, manufacturing, repairing, maintaining, or using the items that are subject to restrictions. In terms of services, the new addition and the more broad prohibition is that of the horizontal, is the one that relates to horizontal services. Here we have a prohibition whereby it is prohibited to provide services to the government of Russia or any company that is established in Russia. There are certain categories of services, but when it comes to the recipient, we do not care whether the recipient is, for example, listed in the EU sanctions list. We do not care if the services relate to a restricted item, namely an item that cannot be exported or sold or purchased. Instead, here we have a very broad prohibition that can, for example, cover the provision of services from an Israeli EU parent company to their Russian subsidiary. Now, the services that are covered, there is a closed list on the one hand, but the categories included in this list are very broad. We have accounting and auditing services, business services, advertising services, legal services, engineering services, and a big category which is also very broad is that of IT consultancy services. And here, what is covered is both the installation of computer hardware and software, as well as software implementation services. And this at times can go as far as to covering software updates, for example. The key takeaway here is that because we have such a broad prohibition, and especially as regards IT consultancy services, every time IT services form part of a transaction that has even a remote touch point with the European Union, we would advise that a further check is done. Not all IT services are covered by this category of IT consultancy services. Nonetheless, it is imperative to identify exactly what is being provided and whether a compliance risk could arise. Now, not everything is very grim and gray. There are a few derogations, as Isabel mentioned before, for the targeted sanctions. Also, as regards trade sanctions, there are derogations available, namely provisions in the regulations on the basis of which a company can go to the EU member state authorities and request for an authorization. However, as regards the horizontal services prohibition, one point to note is that although the European Union allows the provision of certain services that are in favor of certain Russian entities that are owned or controlled by certain partner countries of the European Union, such as the United States or Japan, Israel is not yet included in this list. Turning quickly to the UK sanctions, and just in view of time, we wanted to highlight a few points of difference, because in general, the structure of the two sanctions regime corresponds to some extent. As Isabel mentioned before, the sanctions restrictions are not exactly the same, so different assessments need to be conducted under its regime. But just to highlight, we wanted to flag that the UK sanctions list is not identical to the EU sanctions lists. Therefore, what Isabel mentioned before, that it would be advised to go and identify whether a counterpart is listed in the EU sanctions list. A separate assessment needs to be conducted when it comes to UK sanctions. Moreover, for financial sanctions under UK law, there are no horizontal restrictions for transactions with Russian state-owned enterprises. And finally, and we will see that a bit later as well, when it comes to licensing, while in the European Union, the member states authorities may license only on the basis of what is found in the regulations, the express provisions that allow the authorities to give a license. In the UK is significantly different. What we have there is the discretion of the competent authorities to authorize the types of conducts that they deem appropriate. Having given a brief overview of the targeted, the financial, and the trade sanctions, we wanted to quickly give you a bit of detail when it comes to who enforces these sanctions regimes that we have discussed up to now. Now, when it comes to the EU sanctions, what we have is a decentralized and fragmented regime. Now, what does this mean? On the one hand, we have the European Commission, which is responsible for the uniform application of the sanction across all member states. However, the one that is responsible for enforcing the sanction, applying the penalties in cases of violation, receiving requests for licenses, and granting licenses, these are the member states' authorities. So here we see a two-level system. And although it is possible to reach out, for example, to the European Commission and ask questions with respect to the interpretation or application of the sanctions, what we normally see is that the European Commission would refer us to the member states' authorities that are the one that actually will be called to apply the sanctions. One disadvantage of the system is the fact that the penalty systems vary significantly. It is dependent on the national law of its member state, how to deal with violations of the sanctions until now. And here we see a great divergence into which member states criminalize the sanctions, namely make the violation of the EU sanctions a crime. And what we see from the European Commission is an effort to introduce some legislative initiatives that will at least create some minimum rules when it comes to the penalties. The idea is not because we have many enforcers in the European Union that the EU sanctions are not enforced. Penalties are applied. These penalties involve monetary penalties, imprisonment, and the efforts of the Commission is to make the violation of sanctions an EU crime, and thus to force all member states to criminalize the violation of the sanctions. Now, quickly, before I give the floor back to Isabel, when it comes to UK sanctions, here we have a centralized system. It's not the same as in the EU. In terms of targeted and financial sanctions, there is the Office of Financial Sanctions Implementation, OFSI, which is the one responsible for the enforcement of financial and targeted sanctions. And then when it comes to trade sanctions, we have the Export Control Joint Unit of the Department of International Trade, which alongside with the UK Customs, they enforce the trade sanctions, provide licensing, etc. Also here in the UK, we have a penalty system that is in place, monetary fines, imprisonment, criminal liability for directors of companies that violate the sanctions. So here it's a more centralized system, without that meaning that in the EU there is not enforcement of the sanctions, because we do see enforcement, and as times pass, judgments starts to emerge, so it is becoming stricter. And I think that leaves me, we have also the licensing. I'm sorry, Isabel, before we move forward. We've mentioned the licensing before, so here we just wanted to give you a few highlights, because this is a specific question, like if something happens, where can we go to get a license, to get an authorization? If we identify that our conduct could violate potentially the sanctions. Now, on the EU side, we have specific authorizations. As we said, there are grounds. A license must be requested before the conduct is undertaken. The member states authorities do have the possibility to issue block licenses. These are licenses that can cover multiple types of conduct from multiple entities, and we have right now an example from the Luxembourg authorities. However, because of the decentralized nature of the system, what we see is lack of transparency, either in the sense that we do not have information about licenses being filed for, licenses being granted, about the whole process to be followed before the member states authorities, and also we see a bit of friction when it comes to coordination, because if we have a transaction that passes through, let's say, many member states, has touch points with many member states, it is not very clear how the member states will coordinate when it comes to licensing the various actions that form the transaction. Now, for Israeli companies, I think the key question when it comes to authorizations received by member states is which is the competent authority, and Isabel touched upon this before as well. Depending on the type of the transaction and why that transaction touches upon the EU. For example, an EU bank has been used, or an EU reseller has been used in a sales transaction, or an EU insurance company has been used in the shipment of products. Depending on the specific touch point with the EU, this is what will determine which authority is competent. For example, if the EU reseller is established in Belgium, it would be the Israeli company would need to approach the Belgian authorities to request for a license, and so on and so forth. And to close this, when it comes to UK sanctions, as we mentioned before, it is on the discretion of the authorities to issue licenses. There are no specific grounds. We have many general licenses in the UK that are issued and companies can request to be covered by those licenses. However, both under EU and UK sanctions, a key similarity is that the authorities are not willing to issue comfort letters. So for example, if there is uncertainty by a company on whether or not its actions would violate the sanctions and they would want to reach out to the authorities would not be willing to provide written assurance that certain type of behavior does not violate the sanction. So with that, I will give the floor to Isabel to close this presentation with due diligence assessment.
Thank you very much, Antigone. Now, this outline of the EU sanctions and the recent developments probably gives the impression that this is all very complex, and it is in practice. But how do you go about as an Israeli company if you have to comply with the EU sanctions to ensure that you do the necessary due diligence and that you do compliance? Now, due diligence is the key message here, and that is because it allows you to verify whether you need to comply with the sanctions, whether there is a sanctions compliance problem, a risk that is arising, but it also protects you in case you have done the necessary due diligence and then afterwards a problem nonetheless arises. The position of the EU is that if you do all the necessary due diligence and then afterwards there's a problem with the sanctions and reasonably you could not have known about this, that in principle there shouldn't be any liability for you as a company. So what are then the steps as part of this due diligence? What is the methodology that you can implement in your company and the internal compliance programs that you can develop? There's basically 4 steps: screening the risk, assessing the risk, checking the compliance, and then continued monitoring. Screening the risk is the first step. And it in essence means that you have to collect information. We've already mentioned this a few times during our presentation. You have to collect information about the products, about the services that you might be providing, about all the various parties to your transaction. Those might be direct parties, but also indirect customers might need to be verified. So you need to know your customer, in other words. You need to understand where are the goods or the services going, and possibly where are they coming from, and what payment channels are being used, because as we mentioned, there's many financial sanctions and many Russian banks are also included in the EU sanctions list. So you have to collect this information. Some of that can be done based on contractual documentation, but most likely, as we already mentioned, you will have to send questionnaires to your business partners. And that allows you to determine whether there's a risk in terms of targeted sanctions, if there's a sanctioned bank involved, if there's a problem because of the country of destination of the goods, namely Russia or Belarus. Is there an issue of circumvention of the sanctions? What mode of transport might be used? And any other Russian link that is present. So for that purpose, as we said, you can use questionnaires, you use the sanctions screening list. There's some databases that can be employed, and you can also resort to the EU sanctions map. Based on that screening of the risk, you have to assess the risk. And we already mentioned during our presentation a few times, red flags. And we want to add a few more to those potential red flag lists. For example, if you're trying to collect the information and it turns out there's some unknown parties to this transaction, or it seems that they are not willing to come forward with information, or it turns out there's a state party to the transaction or somehow involved in the transaction, or there's a problem with the source of the payments. These are all examples of red flags that immediately result in the risk of a higher compliance risk. So in assessing the risk, you basically want to determine whether it's a low risk, a medium risk, or a high risk. If it's a low risk, you can move forward to the last step of the assessment, namely that you move forward with the transaction. But you just want to be careful that whenever something changes in the transaction, that you verify the transaction again. And also you want to verify whether the sanctions have changed in the meantime over time. And as you know, we already have a 9 sanctions package of the EU, so the sanctions are rapidly changing all of the time. If you identify a medium or high risk, you probably need to suspend the transaction and pause and reflect on what actions need to be taken to ensure compliance. A high risk would, for example, be the situation where there is a listed person or entity involved. There, basically, the only way to move forward would be to ask for a license. A medium risk might be that you need to have a careful look at what are now the specific products. You might need to kind of see if you can restructure the transaction to avoid a Russian counterpart. Here again, you might need to also ask for a license. So that's kind of a risk assessment that needs to happen for each transaction. And then you have to ensure that you comply. As I already mentioned, that could be in the form of an authorization or a license that's being asked. You might need to also amend the contracts for the transaction. And even then, for medium or high risk, you always need to keep in mind any new developments regarding the sanctions. So that sums up our presentation. In the version that you will receive after this webinar, you will find some very helpful links on how to go about checking the lists of the EU sanctions lists or further information to guide you in this compliance process. Thank you very much for your attention.
Thank you, Isabel and Antigone. It was very interesting. And now I'm happy to present our next guest from Arnold & Porter law firm, who will explain on the US economic sanctions and export controls and give an update on the new US export controls for China. Arnold & Porter is a US law firm with 14 offices in the US, Europe, and Asia. The firm focuses on regulatory, litigation, and transactional matters with a particular emphasis on cross-border transaction. And today we have with us John Barker. John is a partner in the national security practice of Arnold & Porter in Washington, D.C., where he advises on export controls and trade sanctions. He previously served in the U.S. Department of State as Deputy Assistant Secretary of State for Non-Proliferation Controls, and prior to that, as Deputy Assistant Secretary for Export Controls. John, the floor is yours.
Great. Well, thank you so much. And I'll go ahead and share the screen here. And if you can tell me if you can see that now.
Just if you can put it in presentation mode. Perfect.
Great. So we're going to talk a little bit today about export controls and trade sanctions on Russia and Belarus, as we talked about before, and also give a very brief update on some of the new U.S. export controls on China. So the first thing we want to understand from a U.S. perspective is there are several agencies that are involved. There are both agencies that deal with trade sanctions enforcement as well as export controls enforcement. And for Russia, Belarus, and China, you have to look at both agencies and both sets of jurisdiction. So let's first talk about the agencies that apply. There are basically 3 agencies we're going to look at from the United States perspective. The first is the Office of Foreign Assets Control at the U.S. Department of the Treasury. They deal with trade sanctions, basically transfers of goods, software, and technology, but also financial flows. The second is the U.S. Department of Commerce, Bureau of Industry and Security, which deals with the export administration regulations, focusing primarily on technology flows, goods, plants, and equipment. And finally, there's the State Department. The State Department has two areas of jurisdiction under sanctions. First, it deals with what we call secondary sanctions. This is the extraterritorial application of US law. We've talked a little bit already about under the EU regulations. In the UK, there generally is not an extraterritorial application. But from a US perspective, the US does apply its jurisdiction worldwide if it involves US goods, software, and technology, or transfers involving the US. The State Department also regulates the transfers of arms and arms-related technologies. So let's first talk a little bit about the Russia and the Belarus-related sanctions. So US has a very comprehensive set of sanctions on Russia and Belarus, and also dealing with certain sections of Ukraine, Crimea, Donetsk, and Luhansk. But it's important to identify that there is not an actual total embargo. There is some business that US persons, US companies can do with Russia and with Belarus. And of course, restrictions would not apply to Israeli companies too. There are many transactions that Israeli companies could deal with that would not trigger any involvement of US sanctions, particularly for low-level technology and for humanitarian goods, agricultural products, medical products, and medicines. So let's talk a little bit about first embargoes dealing with Ukraine. There is an embargo dealing with certain sections of Ukraine, Crimea, Luhansk, and Donetsk, and they basically prohibit any types of transactions there. There are some exceptions for humanitarian transactions, et cetera, but generally you can't have any transactions involving those sections of Ukraine. Most of the sanctions that the US deals with are listed on a list. In other words, there's a list of prohibited parties. It's called the Specially Designated Nationals List, or SDN list. There's also a separate list called the Sectoral Sanctions Identification List. This list imposes less stringent controls, basically a prohibition on financing. The key element here is to check the list. The US publishes lists changes frequently, oftentimes several times a week. There are additions and sometimes subtractions to the list. So what's an example of a company that ran into problems in dealing with the list? Well, Amazon, of course, you've heard, very large company. They had some transactions that involved prohibited parts of Ukraine, as well as with Iran and Syria. And they paid a fine, a small fine from Amazon's standpoint. But the key element is whenever you have a US enforcement matter, you want to avoid that if all possible, because it will take time and effort away from your business. Whether the fine is large or small, it will be very disruptive. So let's talk a little bit about the US nexus. Just as Isabel outlined, from an EU perspective, if there is an involvement of EU parties in the transaction, even if you're an Israeli company, there can be jurisdiction. Same way from the United States. US sanctions can apply to a non-US person if there's a US nexus. What could be a US nexus? Most dollar-denominated transactions settle through the US banking system, so that would have a US nexus. Any involvement of US persons, so if you have any employees who are US citizens, dual citizens, or US permanent residents, we sometimes call them green card holders, that can apply to assert jurisdiction. And any activities through the US, particularly cloud-based computing support, any data processing, any banking, and any goods, software, and technology. So what's an example of a non-US party that caused a violation? Well, there's a Singapore bank involved where there were some transactions that went through the US, and even though there were no other aspects of US jurisdiction, they paid a very large fine to settle it because they routed transactions through the US. And we've certainly seen for some of our clients where they have a transaction that has nothing to do with the US except for the payment in dollars, and that's been enough to assert OFAC jurisdiction. Also, very similar to that of the UK and the EU, the US has a rule, it's called the 50% rule, which basically says if you have a prohibited party that owns one or more subsidiaries or entities, 50% or more owned by a prohibited party, that party is prohibited. What does this mean in practical terms? It means you need to check the list, but checking the list is not sufficient in and of itself. That's because you have to do due diligence to find out who the owner is of the party and check the ownership of those entities against the prohibited list. You can have a situation, for example, where you have a subsidiary that is not listed on the list, but is controlled, for example, by a Russian oligarch. If the Russian oligarch was prohibited, then the subsidiary would be prohibited. There's also a prohibition on new investment in the United States. Generally, of course, this is not going to apply to non-US entities, but to the extent that a US person is involved in new investment, is facilitating it or guaranteeing it, there will be a prohibition. There are also types of banned services from a US standpoint, including accounting, trust, and corporate formation services and management consulting services. There are also extraterritorial applications of US law in enforcing the EU and UK and US price cap policy on crude oil and petroleum products of Russian origin. Basically, what that says is, to the extent there is US jurisdiction, and in some cases, even if there's not, through secondary sanctions, the US can apply penalties to entities that engage in transactions involving Russian origin crude oil or petroleum products that don't follow the very specific requirements of the oil price cap. We've talked about primary sanctions. Those are the most likely sanctions to apply. That is, if there is a US nexus, a US person involved, US dollars, US goods, software, and technology. But we also need to recognize from the US standpoint, they're what we call secondary sanctions. Secondary sanctions are basically sanctions that can apply to non-US persons, where the US will impose a sanction that basically prohibits dealing with the US markets. And from a US perspective, the US takes the position that if there are serious national security or foreign policy implications of transactions, and a company or organization decides to engage in that, then they can engage in business with the US. It's very rarely used. It has been used, for example, with Russian energy export pipelines, sometimes involving Cuba and Venezuela. It has been very specifically stated by the US that any parties that help the war effort for Russia in Ukraine are likely to be subject to secondary sanctions, even if there's not primary US jurisdiction. There is a possibility of getting licenses from OFAC, but they can take a long time to obtain. Sometimes you can get them quickly, but sometimes they go on, believe it or not, for 1 to 5 years of processing, which of course is not a very business-friendly time in order to get an answer from a licensing standpoint. And that's because the OFAC people work very hard, but they have very few resources. And with their national security and foreign policy implications of licenses, it can take a long time for that to be reviewed by the US government. Fines can be significant, up to $1 million per violation for criminal, up to $1.5 million for civil fines. And each transaction, each shipment, each transfer can be considered an individual violation. So penalties can add up very quickly. But in practical standpoints, what we really worry about from a sanction standpoint is the disruption on your business and the inability to move forward, particularly in being denied access to the US market, as well as the US banking system. We've talked a little bit about the general implications. Now let's drill down on export controls. Remember, as we said earlier, there are two things you have to consider from the US. You have to consider sanctions, and you have to consider export controls. You have to put both of them together. It is possible you could have a transaction that is prohibited under both regimes or only prohibited under one regime. That's why you have to go through the analysis for both. So the US controls most transfers of items subject to the Export Administration Regulations, basically goods, software, and technology that are US origin or manufactured with US products, if they are being transferred to Russia or Belarus. And the transactions apply to US persons and non-US persons identically, because now what we're focused on is the control of the US origins good software technology. The US will basically follow those items, follow that US jurisdiction on a worldwide basis forever and ever, unless it decides to cut off jurisdiction. So items that can be subject to the export administration regulations are on the commerce control list. You won't have to get into all the details for this particular analysis. Just suffice it to say that low-level items can go to Russia without a license, so long as it's not going to the military. But anything that has any technology in it whatsoever, even something like an iPhone or a computer, not real sophisticated technology from a national security standpoint, that still will be restricted in going to Russia from a US standpoint. So we've talked a little bit about licensing, about the requirements. There is a requirement for basically a license for anything that is more stringent, more sensitive than what we call EAR 99 items. So basically lowest level items can go to Russia, can go to Belarus, to non-military end users without a license if you're a US person, or if you're an Israeli company without the need for a re-export license. But anything that's on the commerce control list, and many high technology and even lower level technology items are on that list, would require a license, and it's likely the license would be denied from the US standpoint. So the other aspect that we need to think about, and it's very important for Israeli technology companies. We know that Israel and Israeli technology companies are some of the leaders in the world on technology. But the US has imposed a new control that is really one of the most complicated controls the US has ever imposed in terms of its sanctions. It imposed a similar restriction in dealing with Huawei, the Chinese entity. But now what it basically says is, if you use US origin software and technology or plant or major components of equipment to manufacture a product, even if there's no other US nexus, that can assert US jurisdiction. What does that mean in practical terms? It means that if you bought a plant, or if you bought equipment from the US even many years ago, and use that equipment and don't involve any other types of US origin products, goods, software, technology, the mere use of that equipment can assert US jurisdiction for transfers to Russia. This is probably one of the most complicated rules that the US has ever put in place, and companies are having to go through a very high level of due diligence in order to be able to respond to that rule and to fulfill the requirements. So we talked a little bit about Russia and China. Now, sorry, we talked a little bit about Russia and Belarus. Now we're going to talk for a few minutes about China export controls. And I think before we get into the details of China export controls, it's important to step back for a moment and contrast Russia, Belarus, and China. So for Russia and Belarus, the US basically has very onerous restrictions on transfers. There are restrictions on dealing with prohibited banks, with prohibited persons on lists, with prohibited transfers of technology. Basically anything that is higher or more sensitive than EAR 99 would require a license to go to China, to go to Russia or Belarus, and all things going to the military would requirement. China is much different. The US has a very close trading relationship with China, and even though there are some new and comprehensive controls on dealing with China, it's important to recognize that there's an incredible amount of trade between the US and China. And it's really only a function on the highest level of national security goods where the US has restrictions. You know, as you're probably aware, the US sends many types of technology exports to China that it wouldn't send to Russia. For example, aircraft, goods, software, and technology. Software, particularly in the technology area, it's fine to transfer to China, so long as it's not for military end uses or prohibited persons. So the first thing that we're going to outline here is some new controls that were put in place in October. And I appreciate that this would likely only apply to a few of the companies that are on the seminar today, but it's important to recognize how serious those controls are. Basically, there are new controls in dealing with semiconductors and supercomputer equipment. They are very technical controls. You basically have to go through the commerce control list and determine if the technology is of a sufficient level. But what the US has said at a very broad level on dealing with semiconductor and supercomputing equipment is it intends to restrict or not permit transfers at any higher level technology than China already has. The theory the U.S. has espoused on this is that some of these technologies can be used by China's military and so therefore are prohibited. So if you're a company that is dealing in the supercomputer or semiconductor area, this is something you want to spend quite a bit of time on. I've put all the details here as a summary of the items that you can look at in more detail after the seminar. But suffices to say, it's again a very complicated rule that requires a close review. But there are also other restrictions that you're going to apply to really all of the companies that we're dealing with on the seminar today. And those have to deal with prohibitions that are listed on temporary denial orders, denied persons lists, and what we call an entity list. An entity list is a list of companies that require licenses in order to receive U.S. origin technology. And unlike, for example, most licenses for Russia, it is possible to obtain licenses on the entity list for transfers to China if you have U.S. origin goods, software, and technology that are subject to those retransfer authorizations. The restrictions are particularly acute and focused on for exporters that are in the high technology industry, semiconductor equipment, supercomputers, and any transfers, to support the Russian war effort against Ukraine. The U.S. is very concerned about transfers going to China and then transfers from China going to Russia. And just to conclude on our China-related transactions, again, it's very important to check the list and to understand that the U.S. has many types of support for transactions with China. It's a close trading partner, and of course, it would encourage Israeli companies to have the same level of trade as U.S. companies, but it also imposes restrictions on dealing with transfers to prohibited parties. So we're going to talk a little bit, just very briefly wrap up here on what you should do to remain in compliance. So the first thing is you need to assess whether you have any U.S. persons involved, whether there is going to be any goods software, technology that is U.S. origin, but also assess your non-U.S. persons risks, whether you are at risk of causing a violation, whether there is any good software technology that is in Israel that is of U.S. origin or was made with U.S. plant and equipment, and then determine if a counterparty is involved. We've had many transactions where there is not a prohibition on sending the item, but there has been a prohibited bank or freight forwarder that is involved, and that has triggered sanctions against U.S. and non-U.S. parties. What do you do to remain in compliance with sanctions? Well, first you need to determine if you've got any U.S. persons involved. If you have U.S. persons in your Israeli companies, dual citizens, U.S. citizens, or permanent residents or green card holders, they are subject to U.S. sanctions as if they were in the United States. Also, if you have any type of cloud computing support, any dollar-denominated transactions, any support from U.S. banks, that can trigger your jurisdiction. Just like Isabel outlined, you need to conduct due diligence on your customer, probably send them a questionnaire, and also check all intermediaries to the transactions. What do you need to do to remain in compliance with U.S. export controls? Basically the same approach, determine if there are any items that are of U.S. origin, whether they are subject to what we call the de minimis rules, meaning they have more than 10 or 25% U.S. content in your Israeli origin products. And the most complicated one, as I mentioned earlier, is this foreign direct product rule, where the U.S. can assert jurisdiction merely because a company uses U.S. origin technology, plants, or equipment to manufacture their products. Any transactions that are going to Crimea, Donetsk, or Luhansk are particularly ones that are going to be focused on. So you need to make sure to check due diligence, including the ownership, to check on the 50% rule. When you're checking the list, check for alternative names. There have been some famous cases where somebody mistyped something for their sanction search, and they had a typo in their sanction search, and they missed the sanction search, and the U.S. decided to impose a penalty anyway because they said they didn't exercise due diligence. So you have to be very careful in terms of your sanction searches. There's an example of a company that didn't do what we call reverse IP screening. They didn't check their domains to find out whether there had been transactions that had been involved in Cuba, Iran, Syria, and North Korea, as well as the Crimea region. We expect the same standard would be applied for Russia and Belarus related transactions. What are examples of red flags that we see in transactions in dealing with Russia and Belarus? Anytime there's a switch at the last moment, anytime where you had an order that used to go to an entity in Russia and Belarus, and now they switched it to Kazakhstan or another country, they might be using that as a cutout. Anytime you have a freight forwarding firm as the final end customer, any type of atypical shipping routes, you all know your businesses very well, and you would be able to recognize that, and the U.S. would expect a company to do due diligence just for those purposes. Now, for those of you who are real gluttons for punishment, if you really want to get into the details here, I have listed here the really hundreds of pages of regulations. And this is the kind of thing that I get really excited about. I know that you are just as excited as I am. And so after this seminar, you'll have all the links here that you can find those. But literally there are multiple executive orders, many types of general licenses, just like we heard about in the EU, and an entire set of lists that you can look at in detail. Bottom line from all of this, in order to comply with US law, it does take a fair amount of time and effort. By the same token, those companies that are willing to invest in that time and effort can be ahead of their competitors, can be ahead of their peers, and can make compliance a competitive advantage. With that, I will conclude. Thank you.
Thank you very much, John. This information was very useful, is very useful. And now for our third and last part of the webinar, we will review 2 case studies in order to understand how Israeli companies should address the sanctions of the US and the EU. This part will be led by Naama Margalit-Margolis from Shibolet & Co. law firm, and the participants in the panel will be Isabel and Antigone from Van der Bellis and John from Arnold & Porter. Shibolet & Co. is one of Israel's largest full-service law firms. Shibolet provides corporate, commercial, and regulatory support to a wide range of globally minded customers. Naama Margalit-Margolis is a partner at Shibolet & Co. and leads Shibolet's global trade control practice. Naama advises on various Israeli trade control legislation and supports compliance activities. She also assists Shibolet's clients in flagging and attending to global export control and sanctions issues. Prior to work in private practice, Naama worked as legal counsel at Israel Aerospace Industries. Naama, the floor is yours.
Thank you very much, Dikla, and hello to everyone. I'm going to share my screen. Okay. Hopefully everyone can see it. Terrific. Okay. So far in today's webinar, you've heard about a number of different regulatory frameworks and sanctions regimes against Russia, as well as some additional trade limitations. And what I'd like to do in this last part of the webinar is to help you tie things together and to help you with a strategy for how to account for all the various pieces of this regulatory puzzle, each of which can be potentially applicable to you in your day-to-day activities. So for this purpose, we put together a couple of case studies which will give you a practical feel for how to apply the principles that we discussed today. However, before I get into addressing specific situations, I do want to impress upon you a very practical general strategy for managing compliance with all these various regimes. And it's a strategy that's been alluded to a few times today, but I want to demystify it a little bit, which is the internal compliance program. So let's talk a little bit about the internal compliance program before we get into specific case studies where that program gets implemented. So the first thing that I want to say about the program is that it's not a one-size-fits-all. You are all coming from very different industries, companies of different sizes, different risks. So it really has to fit your particular circumstances. On the other hand, we do see that across regulators and regulations, compliance programs do all have certain hallmarks, certain commonalities and pillars that you can start attending to tomorrow morning. So when you ask yourself, what can I do practically to prevent a violation pitfall? Here are some general steps that you could take, which will have you in a good position to deal with compliance challenges thrown your way, even before you get to the particular case study. So the first thing that I want to point out is management commitment. It's really important to go with this webinar to your management, to raise the flag and get them involved with implementing a compliance program. Because the fact is that nobody in your organization is going to get on board with compliance if management isn't getting on board. So you really need to set the tone from the top. Then the second thing to do, which all regulators talk about, is to do a general risk analysis. And the general risk analysis can inform the kinds of compliance measurements that you can take, even before you get to a particular case study. So when we talk about general risk assessment, first of all, you can look at the general touch points that you have to US, EU, and UK sanctions. They don't all have to do with a particular transaction that comes your way. They can have to do with general commitments that you've made. For example, commitments to your investors to comply with US or EU or UK sanctions. You can look at your long-term framework agreements with your vendors, what kind of commitments you have there toward insurers or your cloud platform providers. Those are not necessarily transaction specific, and they can inform your general approach to compliance and touch points. And it's also very important to remember Israeli banks. As my colleagues mentioned earlier, there are also Israeli business partners that have taken on a certain level of compliance that will inform your transactions and compliance activities as well, not just on a case-by-case basis. Also look at your key personnel, look at the people in your business. It's not necessarily a transaction-specific exercise, and it can inform your understanding of how and what you need to comply with. And then finally, think about the indirect touch points. We talked about exposure to secondary sanctions that can trigger a certain policy decision. And you also have to look at your Israeli regulators who haven't adopted a Israel-specific sanctions regime, but as Karen mentioned earlier, are implementing an Israeli policy of compliance in a way that can also affect the licenses that you will or can get from the various Israeli regulators that you already interface with, and can inform your general compliance decisions. So for example, if you need to get export control licenses from various Israeli regulators, their decisions may be informed by Israel's general policies. Now, you can also look at your general risks. You don't have to wait for a particular transaction to come to your table to look generally at what you sell or what you buy, to know your products and services. We talked a lot about knowing your customers, but there's also an importance to knowing what you sell or buy, because as we talked about earlier, there's certain services which are prohibited not just in relation to a particular customer, but can be subject to a sectoral or a horizontal sanction. So you might as well get familiar with what you do or what you sell or what you buy vis-a-vis the various sanctions regimes, and that'll inform your general approach to compliance. Think about also how you make your sales. If you make your sales through, for example, an online platform, then you have exposure to all kinds of customers from all kinds of places in the world. So before you get to a particular deal, you can already assess that you have a certain risk of transacting with embargo territories. So that could inform your general risk. And you can also look at your customer base in general and see whether you're operating with a more high-risk customer base or vendor base, and that can also inform your compliance measures. And then you can also take some general compliance steps even before you get to the particular case study, whether it comes to refraining from giving a certain type of service in general to a certain territory or to Russia, whether it's adopting geo-blocking software that will have you distance from transactions with the LNR, GNR, Crimea, other embargo territories. These are general compliance steps that you can take even before you get to scrutinizing a particular transaction. Same thing with looking at your customer base and then making a decision, a policy decision, where to refrain from doing business. And then once you've done your general risk assessment, the next step is really to create controls, to create procedures and processes that are commensurate with your touch points and with your risks. And the case studies that we'll talk about kind of speak to those internal procedures and controls, how we look at those procedures and how we go through those procedures step by step. But it's very important that once we've created a procedure and we've created a policy, that we don't leave it on paper, that we test it and audit it, that we see that whatever policy that we've created for dealing with each case, that we actually check to see that it works. And then finally, if we talked about the top of the organization in the beginning, we really have to make sure that the information properly trickles down to the people who are actually doing the day-to-day work and interacting with these transactions and are kind of living the case studies. So those are kind of general pillars for compliance even before we get to the case studies. And now I'd like to talk about a couple of case studies here with my colleagues and try to assess them with their help and see kind of what to do in particular circumstances. So the first case study that we have for you is a case study that involves an Israeli company that has a B2B online platform for providing various business courtesies from international customers to companies in Israel, the US, and the EU. So before I get to the particular transaction, note that there are a few general types of activities that the company does or touch points that it has that can already kind of inform its compliance stance. But now it received a particular order via the platform from a Russian customer to supply gift boxes, including chocolate and vodka originating in Russia, to hundreds of the Russian customers' business partners, including partners in Israel, the US, and the EU. And the Israeli company wants to purchase and import the products from an unrelated Russian vendor in Russia. So how do we think about approaching this case study? First of all, we have to look at our touch points, meaning examine our own transaction touch points before we look at the other side. And we need to do this in relation to each one of the sanctions and export control regimes that may be applicable to us. Due to time constraints, we've only taken a look here at US and EU sanctions. That isn't to say that you shouldn't look at UK sanctions, it's just a time constraint matter here. But let's look first at the US sanctions and export control side. So we need to decide whether there is a touch point based on the currency of the transaction that we've chosen. Is our pricing in dollars? That can affect our US sanctions touch point. Same thing with the various vendors that we use in order to provide our services. So if we're using a US bank or a US online platform, or a US distributor, or a freight forwarder. All those things can create a touch point which require our compliance as an Israeli company with US sanctions. Same thing if we have a US subsidiary, or we have US persons, whether generally supporting all of our activities or particularly supporting this transaction. And in this case, we also have products entering the US. That's another touch point. And we also are providing a service to US persons or entities. So that's another touch point. And again, don't forget that this is in addition to the general touch points that can inform our particular transaction. And so John, before I move on to the UK side, is there anything that you want to say about the touch points in addition, something to look out for, think about?
So I think you've done a really good job of summarizing it. You can see on the left-hand column there that there are many ways that U.S. jurisdiction kind of reach out and grab a transaction. And it's important to recognize that not only are these touch points, but there can also, for some transactions, be secondary sanctions. Probably not for this example, but we always have to worry about that. So good summary.
Thanks, John. And on Isabel's side, on the U.S. sanctions side, we are looking at many of the same touch points, but they're not necessarily 100% the same. So Isabel, do you want to touch on that?
Yeah, just briefly, the issue of using euro as a currency is less easily going to result in a jurisdictional basis under EU law as compared to US law, as John explained. And just to make the general point, I think if you looked at the facts of the case study, they only mentioned one possible EU link in the sense that the gift baskets are being sent to the EU customers. But here you see examples of a series of questions you need to ask yourself with respect to any transaction. So it might not be the case that when you first kind of see the proposal for a transaction there's so many signs of EU touch points, but in essence, I think what Nama nicely has illustrated is all these kind of additional questions that need to be asked to verify whether the EU sanctions apply.
Thanks, Isabel. So now that we've figured out that we probably do have some US and EU touch points, there's the next step in dealing with this particular case, which is really doing our due diligence and figuring out whether or not we are risking a violation of US or EU sanctions or export controls. And we're going to take it step by step. So we're going to talk about US sanctions first. And the first step is really to gather information. And when we gather information, we review several types of information. So first of all, we have to review the subject of the transaction. We've got products here. We've got the chocolate. We've got the vodka. We need to think about where they come from. We need to think about whether they fall under lists of sanctioned or controlled items. And of course, we also need to review the parties to the transaction. And I think that what is usually obvious to companies is to review the customer. But it's important not only to review the customer, it's really important to review any additional party to the transaction that can be involved, whether it's Russian vendors, whether it's distributors, whether it's the freight forwarder that's bringing the chocolate and the vodka over to Israel, whether it's on a ship. There are a few parties that need to be screened. And of course, don't forget the banks. Don't forget the Russian banks, many of which right now are precluded from doing business, whether by sanctions or by Israeli banks. So we really need to look at a number of different parties. And once we've gathered all of the information, then we need to analyze it. And we've gathered the information. I also will remind everybody, it can be through open sources. It can be through for-pay screening services. It can be through questionnaires. Use whatever means is available to you. And there is more than one type of means. Of course, there are also lists on the various websites of the regulators and US regulators, but they won't help you with the ownership per se. So for that, you need to reach deeper. So now, John, we've gathered our information and we have some findings about what it is that we're selling, buying, who it is that we're buying and selling to. So what do you think about the information that we've gathered?
So one of the things that's very useful about this example is if we step back for a moment, we say, like, who really cares about vodka or chocolate? I mean, it's not a national security perspective. There's not a national security risk involved in vodka and chocolate. But yet you've actually outlined through this example how a Israeli company could be tripped up by US sanctions if they have transactions that are dollar denominated that go through the US, and there are prohibited parties involved here. Here, we may have an example of a company that is owned 50% or more by an entity on the SDN list. And if you had a supplier involved in that, that could trigger the sanctions. And also, vodka is prohibited as an import. Right after the sanctions were put in place, the US prohibited vodka and caviar, among other items, from being imported into the United States. And so this is an example where if you were to step back and say, why do we care about chocolate and vodka? Well, actually, if this company went forward with the transaction through the US banking system involving an SDN and involving vodka on a prohibited level, they're going to spend a lot of time with lawyers, and that's one of the things we want to help you avoid.
Thank you very much, John. So I think the bottom line with this transaction is that even though it seems kind of innocuous, it's actually a high-risk transaction. And that's really something that I want to impress upon the attendees today, is that it's not just about missiles or munitions. The sanctions have really been applied toward a wide variety of transactions and products. So you really have to come to every transaction with an open mind and with a certain level of suspicion and diligence in order to make sure that you're not going to fall into a violations pitfall. And even though with this particular transaction, there's good reason to stop at step 3, I do want to just at least touch upon step 4 in the theoretical event that we're not talking about. Let's say we swap the beverage and it turns out that the Russian customer is actually okay. Don't forget that the work doesn't stop with approving the transaction, because keeping up with sanctions these days is really keeping up with a moving target. So you've got to keep monitoring the situation, and you have to protect yourself contractually against a situation that the sanctions stance of the various regimes that apply to you will change with respect to your transaction. So now I want to move over to the EU side. And here, step 1 is kind of the same or very similar in that we've got the same gifts, we've got the same parties, but we're looking this time at different lists. We're not looking at the same lists, we're looking at the EU list. And therefore, the conclusions that we have might be a little different. And Isabel, please help us analyze the information that we've gathered here in step 2 and 3.
Thank you very much. So the first point, to just a general point to remark, is that you're probably starting to understand that whether it's for US sanctions, EU sanctions, UK sanctions, that it's the same method you use. You can have one internal compliance program to deal with all these sanctions problems. And it's the same questions to always ask, but then the answer to the questions that Nama already signaled might be different. So here in this situation, similar as what is the case under the US sanctions, you always first check, is there a problem with the targeted sanctions? Is anyone involved in this transaction listed? And then next you look at the trade sanctions and then any other sanctions that might apply. So here, in terms of the facts that we gathered, is that, again, the Russian vendor is not listed in the EU. That's good news. But then when we look at the Russian customers, there's a problem because person A is in the list, and he has 21% of the shares. Company B is not listed. That's good news. But then it gets a bit more tricky because person A's son is also a shareholder. He's not listed. And at that point, there's definitely a red flag that goes up for us, not only because of the fact that person A is listed, but we want to look at the relationship between person A and his son and the extent to which actually A, in fact, has 49% of this company and might perhaps not be owning it, but nonetheless be controlling it. So extra due diligence would be required here. Similar to what's the case in the US, the EU has also kind of listed vodka in the list of goods that's subject to the sale and purchases prohibition. So that's a problem. Chocolate is not listed. And we would also then verify if there's any problem with a horizontal services prohibition. Remember, those are the restrictions that apply regardless of any link to a listed product. But here we could note that after-sale services in general are not covered. So in sum, this would be a high-risk transaction also under the EU sanctions. And it would mean probably, yeah, removing vodka from the gift basket for sure. And then for the targeted sanctions, extra due diligence is required. And definitely here we'd be asking for further information, sending a questionnaire, etc. Thank you.
Thanks very much, Isabel. So step 4 here is also the same contractual protections, just different jurisdiction. And we'll move on to the second case study. No chocolates this time, but we do have an Israeli company that distributes low-level commercial electronic components and related software. It also provides customer support. And the Israeli company has received a purchase order for components, related software, and technical support from a trading company in the UAE. So not from Russia, but the shipment is to Russia. And in addition to looking at the particular order, we also note that the UAE customer was directed to the Israeli company by the Israeli company's EU vendor. And the EU vendor had reached out to the Israeli company after first speaking with its US parent company. So we've got a few twists here in the plot. And the first thing we'll do is we'll look at the same transaction touch points to understand the applicability of the US and the EU sanctions and export control regimes. But this time, I want to focus on some additional touch points that are a little bit more case specific. So from the US side, we are now possibly dealing with US origin items or items that are subject to the foreign direct product rule. So even if the low-level components that we're buying are not coming directly from the from the US, they still may be US origin. And even if they're not US origin, there's still the question of the foreign direct product rule. And then there's a US parent that was involved in somehow directing the purchase order to us. So John, do you want to expound a little bit on those two last touch points?
Right, so you've identified two aspects of US jurisdiction where US jurisdiction can apply to a transaction that is outside of the US. The first one, the foreign direct product rule we talked about briefly, is if you have items that are of a certain level of sensitivity that are manufactured with US origin plants, equipment, goods, software, and technology, even though there may be no element of US origin physical properties in the items or technology, if they're manufactured by the equipment that came from the US can assert jurisdiction for transactions for exports to Russia. And then the second part about the facilitating, again, with the US parent being involved in the transaction, that is direct US jurisdiction. So clearly the US parent is going to be involved and that can allow the US to assert jurisdiction. I think the final thing that we would say here is even if everything on the left-hand column does not apply, even if there was no US foreign direct product rule, no parent involved, and it was purely a transaction between Israel, the UAE, and Russia, if those items are being used to support the Russian war effort, it's very likely the US would consider that for secondary sanctions. So even if the left-hand column, none of it applies, you still need to worry about it. You've probably seen some headlines recently about US origin items. 12 or 13 companies were involved with US origin items that went into drones that went from Iran, which went to Russia, which killed people in Ukraine. And those companies are now scrambling to find out how their supplies were diverted for that. And you want to make sure as an Israeli company, you're not caught by that.
Thanks very much, John. So now let's move over to the right-hand column. So we'll focus here too on really the last two lines, which are a little bit more unique to this transaction. And here too, there may be items that we are exporting from the EU, which trigger sanctions. And here too, we have to think about whether we're facilitating circumvention, which is a new kind of consideration to keep in mind. Isabel, do you want to just say a couple of words on that as well?
I'll let my colleague Antigone take that case study. Thank you.
Thank you, Isabel and Nama. No, I think Nama described it perfectly. If the items are exported from the European Union, then we have contact taking place in the territory of the European Union, and this is why the EU sanctions would apply. Now, with respect to the last box, the point with facilitation of circumvention, as Isabel described before in the presentation, is that even if the Israeli company at issue does not have to comply, if somehow the EU vendor tried to evade their own obligations and outsource the order to the Israeli company, that could be a situation where the EU vendor circumvents their obligations under EU sanctions, and therefore the Israeli company, by accepting the order, they're facilitating circumvention. And this, as Nama has noted, there would be a risk that the Israeli company could be listed in the EU sanctions list and therefore be subject to targeted sanctions, the asset freeze and the prohibition to make funds available. Thank you, Nama.
Thank you, Antigone. So we have good reason now to do due diligence and to carefully consider both the EU and the US sanctions and export control regimes. So let's start with the US. Step one is classifying those components that we want to sell and export, particularly the US ones, but also the ones that could be the foreign direct products of US software technology or US plans or major components of plans. And of course, we still have to review the parties as well. So we've done our review, we've done some classification work, we've looked at the various parties, and now we've got some facts on the ground that, John, you can help us assess.
Sure. So I think the first thing we want to look at is, are there prohibited parties involved? And here we have a situation where we have three owners of the Russian end user. Company A is 24%, company B is 28%, and company C is an SDN, and we don't hit the 50% rule there. Unlike in the EU, where we have to consider control, in the US, we don't need to consider control. So that's the distinction between the US and the EU sanctions, actually where the EU sanctions are stronger than the US sanctions. But some of the items are classified on the Commerce Control List of what we call a 3A991. If it is a military end user, then it's going to be a prohibition on sending those 3A991 items, and including even EAR 99 items on that. So again, it's a high risk transaction here, something to look forward to in terms of due diligence. And maybe the last step is the most important one. You're not going to be able to export the 3A991 items without a license from the Commerce Department. Generally, that license is going to be denied unless there's some specific reason from the U.S. national security or foreign policy they wanted to go forward, maybe safety of flight or something like that, or humanitarian, but generally it's going to be denied. It's also going to take a while to work through. So this is a good example where an Israeli company, in trying to do the right thing, would need to go through the due diligence and see whether U.S. jurisdiction applied and see if there's a prohibition.
Thanks, John. And I think one of the things that is kind of not intuitive for Israeli companies is that EAR 99 is not necessarily like a go, meaning you still have to check who the end user is and make sure that they're not a military end user. So that's definitely something that requires some more scrutiny. And I will also go back to the party involved and say that I had mentioned in this example the consolidated screening list, the CSL, which is a tool that the US has for checking the parties. But if you're checking a company, then you always also have to check its owners as well, which is something that you won't find on the consolidated screening list. So that's always something to check as well before you've kind of cleared your parties. And finally, I will once again mention the fourth step. Even if you've decided to go forward, if it's a high-risk transaction, do protect yourself contractually and keep monitoring.
Right.
Okay,
and now,
now
one thing I should add here is what one would think like who would care about something that's low level item going to a place called Russia? Well, I've been involved in a case where the U.S. Brought an enforcement action against a U.S. company solely for shipping furniture to a prohibited entity. You think of furniture, it's not really a national security element, but the U.S. takes the prohibitions on individual entities very seriously, and I would expect to go after companies, whether they are U.S. companies, Israeli companies, or companies from other countries, if they are shipping prohibited items that are U.S. origin to Russia.
Thanks, John. Yeah, I think that's a non-intuitive point when you talk about sanctions that, have been triggered by fighting. And you have to remember that whatever has been controlled, prohibited, sanctioned is going to get enforced, even if it's vodka or a low-level component. It is what it is. So now moving over to the EU. We've done our first step. We've classified our product. We've looked at our parties and our payment channels, and now we've gathered information about all those different parties, and about our services, about our product, and now we have to analyze it. So Antigone, help us analyze the information that we've gathered.
Thank you, Nama. In respect of targeted sanctions, we see here that none of the owners of the Russian end user are listed in the sanctions list. And at the same time, the Russian end user is not a state-owned enterprise that is listed in the list of SOEs identified by the European Union. So although that could leave us on the clear with respect to targeted sanctions, although I should flag that even if the shareholders of the counterparty are not themselves listed in the EU sanctions list, we would still need to identify the ultimate beneficiary owner of company C, for example, here. So we would need to examine the shareholder structure up to the very end before reaching our conclusion with respect to targeted sanctions. But let's say this has been done, and here we have no issue when it comes to somebody being listed in the EU sanctions list or controlled by somebody else who is. When it comes to trade sanctions, this is a very good example because it gives us the opportunity first to identify that even electronic components and software that are low level, not for example for military applications, etc., they can still be subject to sale and export restrictions. Annex 7 to the EU sanctions regulation expanded the dual use list items that we had also under the EU export control regime with additional electronic items and software. So here, for example, we would have a situation where the sale of the electronic components would be prohibited. At the same time, we saw in the example that Nama prepared that there is a reference to customer support with respect to electronic components and related software. Now, given the very broad horizontal services prohibition that has now been in place, as we discussed before, in this situation, it would be imperative to identify exactly what these customer support services entail and whether they could be prohibited under the horizontal services prohibition and why. Although here we have the immediate customer, let's say being a UAE entity, if I'm not mistaken, nonetheless, all these prohibitions and the horizontal services prohibition specifically apply to any provision of service directly or indirectly to companies in Russia and the Russian government. Therefore, here if the Russian end user is receiving also the customer support and is benefiting from the support, there is a high likelihood that the horizontal services prohibition could be triggered. Now, with respect to the whole issue of circumvention and the facilitation of circumvention that we've referred to there, here we had the EU vendor who redirected the order they received to the Israeli company. Now, as we said before, we could have an issue here of a services prohibition or a sale prohibition, and the EU vendor, by redirecting the order to a non-EU supplier, in here the Israeli company, could be found to be circumventing EU sanctions. Now, if this is the case, at the same time, if the Israeli company went on and accepts this redirected order, there is a likelihood that the Israeli company could be found to facilitate such circumvention. However, as Isabel mentioned before and she explained, this is the facilitation of circumvention is a new and untested criterion for companies to be listed and persons to be listed in the EU sanctions list. We do not have any examples of that criterion being used up to date, so there is a high degree of uncertainty how and when this criteria will be used. However, in any case, if you are involved in a transaction that smells like circumvention, you should be very careful to avoid facilitating, in any case, actions that could be circumvention. I think Nama that closes it. Thank you.
Thank you very much, Antigone. And of course, I'll mention that last fourth step, no matter how good the transaction looks at this point, if it's a high risk, involves Russia, always protect yourself for what may come next week or next month. So that wraps up our case studies, and we hope that in addition to giving you some of the basic information that pertains to where we are today in 2023 with respect to sanctions and export controls, mainly against Russia, but also trade limitations with China, that we've given you some practical tools for what you can do to contend with all these different regimes and how you can kind of deal with it and help your people deal with it on a day-to-day basis. So thank you very much.
Thank you, Naama, Isabel, Antigone, and John. This was very informative. I know you gave a lot of companies very important and useful information to digest. As this issue keeps evolving, we recommend Israeli companies to keep following this issue carefully. We will share the video of the webinar and the presentation with you and upload it to our website. Have a good afternoon in Israel and Brussels, and good morning in Washington. תודה רבה להשתתפות, ערב נעים לכולם.